The legal interpretations of the Supreme Court have become the final determiner in the policies that affect the daily lives of American citizens. Are all branches of the government created equal? Or does the Supreme Court now wield more power than our founding fathers ever intended? Discover our nation's godly history in the American Heritage Series. America, this is your heritage.
The third Chief Justice of the Supreme Court was Oliver Ellsworth. He was a member of the Continental Congress during the American Revolution and was also a member of the convention that framed the Constitution. Like the other founding fathers, he too held strong convictions about religion and public life. Here, for example, is a piece written in the Connecticut Courant of June the 7th, 1802.
The primary objects of government are the peace, order, and prosperity of society. To the promotion of these objects, particularly in a republican government, good morals are essential. Institutions for the promotion of good morals are, therefore, objects of legislative provision and support. And among these, religious institutions are eminently useful and important. The legislature, charged with the great interests of the community, may and ought to countenance, aid, and protect religious institutions. Institutions wisely calculated to direct men to the performance of all the duties arising from their connection with each other, and to prevent or repress those evils which flow from unrestrained passion. The legislature may aid the maintenance of Christianity, whose benign influence on morals is universally acknowledged. It may be added that this principle has long been recognized and is too intimately connected with the peace, order, and happiness of the state to be abandoned.
This is a bust of Oliver Ellsworth, third Chief Justice of the U.S. Supreme Court, who declared that it is appropriate and proper for the state to aid and encourage religion. One of the things that we hear today, and the Court says it's very regular, this is the purpose of the Supreme Court is to protect the minority from the majority. We hear that, minority rights. I don't know of anyone in America that wants to trample on minority rights. Oh, there's a minority religiously or racially or anything else, I'm going to go trample on those rights. That's, people do that, but that's by and large the extreme. That's not the average. The best protector of minority rights is the majority. You see, we ended slavery in America not because the court did anything, the court tried to keep it going, but because the majority said this is wrong. So we passed the 13th Amendment. And by the way, it was a supermajority. It was 2/3 of Congress and it was 3/4 of the states that said we want to end slavery.
More blood.
That's right.
In that Civil War.
But see, the courts weren't good protectors of the right of women to vote. The people said we want women voting. Who did that? Males. Males were the only ones that could vote. Males themselves said we think women should vote, so we're tying our own hands so that women get the right to vote. How is it that 18-year-olds got the right to vote? Because there's always 21. Because we the people passed an amendment to the Constitution that said, you know what, we think that if you're old enough to go out and die for your country, you're old enough to vote. And so we, over the age of 21, are going to give that same right to kids that are 18 and older. If you look at the issue of poll taxes, the Supreme Court was not good on civil rights, but the people were. The people consistently defend minority rights better than the courts do. And the founders understood that. And that's because we, the people, know what we feel. We elect representatives that know what we feel. Therefore, when we put them in office, they can protect what we think is important. Now, you got guys in the court who get appointed for 30 or 40 years. They don't even talk to average people. They run in completely different circles. Wow. And we're saying that 5 of them can tell us what we think and believe and feel and can protect our rights. This whole notion of minority right protection, what the court has done with that. And by the way, I have to back up to say that we had 2 political parties at the time of the founding of America. Federalists and Anti-Federalists. And if you think that our 2 major political parties today are pretty pointed toward each other, it's wimpy compared to what they did back in the founding era. I mean, these guys were vicious back there.
Right.
But what you'll find is the leader of the Federalists and the leader of the Anti-Federalists both made identical statements. George Washington, Thomas Jefferson, 2 political parties, they both said the fundamental principle of the Constitution requires that the will of the majority shall prevail. Now, that's the purpose of the Constitution, is to make sure that the will of the people is what goes into policy. You don't ever have a policy in America that's enacted because 10% wanted it, 90% didn't, but we're going to have the 10% win. That's just not constitutional until the court comes along. And they says, oh no, It's our purpose to protect the minority from the majority. If 90% of you want that, that's not fair for the 10%. So we're going to say all 90% are wrong, we're going to do it this way. That is a complete reversal of everything the Constitution was designed to do. Another Supreme Court justice who adds to the rich spiritual heritage of this courtroom is Joseph Story. Joseph Story was truly a son of the American Revolution. His father had been one of the so-called Indians who conducted the Boston Tea Party, and Joseph Story became a U.S. congressman under President Thomas Jefferson, and then President James Madison appointed him to the Supreme Court to replace the retiring William Cushing, one of the court's original 6 justices. Joseph Story, at age 32, was the youngest justice ever appointed to the court. Joseph Story became committed to the principles of Christianity. Throughout his lengthy legal career, he consistently expressed his strong convictions about the importance of Christianity to civil government. Joseph Story did not believe that American law or legal practices could be or should be separated from Christian principles. As he explained,
one of the beautiful boasts of our municipal jurisprudence is that Christianity is a part of the common law. There never has been a period in which the common law did not recognize Christianity as lying at its foundations. The law pronounces illegal every contract offensive to Christianity's morals. The law recognizes with profound humility Christianity's holidays and festivals and obeys them even to the point of suspending all government functions on those days. And the law still attaches to persons believing in Christianity's divine authority the highest degree of competency as witnesses.
one of Justice Story's most famous legal writings was his 1833 Commentaries on the Constitution of the United States. Notice what this distinguished Supreme Court justice said about Christianity and the Constitution, including the fact that the First Amendment was never intended to separate Christianity from civil government or from civil society.
The First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, we are not to attribute this prohibition of a national religious establishment to an indifference to religion in general, and especially to Christianity, which none could hold in more reverence than the framers of the Constitution. Indeed, the right of a society or government to participate in matters of religion will hardly be contested by any persons who believe that piety, religion, and morality are intimately connected with the well-being of the state and indispensable to the administrations of civil justice. At the time of the adoption of the Constitution and of the First Amendment to it, the general, if not the universal, sentiment in America was that Christianity ought to receive encouragement from the state. An attempt to level all religions and make it a matter of state policy to hold all in utter indifference would have created universal disapprobation, if not universal indignation.
Joseph Story believed that it was improper to exclude Christianity from the government sphere or from the public arena. In fact, he felt that it was so improper that he declared that he would not support anyone who even attempted to undermine or remove Christianity's influence from society. He declared,
I verily believe Christianity necessary to the support of civil society, and shall ever attend to its institutions and acknowledge its precepts as the pure and natural sources of private and social happiness. The man who could subvert its influence will never receive support from me.
strong sentiments from Justice Story, who sat in this courtroom and who today is still called a father of American jurisprudence.
The legal interpretations of the Supreme Court have become the final determiner in the policies that affect the daily lives of American citizens. Are all branches of the government created equal? Or does the Supreme Court now wield more power than our founding fathers ever intended? Discover our nation's godly history in the American Heritage Series. America, this is your heritage.